Members, Mr. Paxton brought this matter to us. Let me repeat that. Mr. Paxton brought this matter to us. In February, after signing a settlement agreement that stopped the litigation process in a whistleblower lawsuit brought against him by some of the highest-ranked individuals in the Office of the Attorney General, Mr. Paxton came to this body and testified before the Appropriations Subcommittee, asking the legislature to spend millions of dollars to settle his lawsuit without sharing any facts about what had happened. Millions of taxpayer dollars. $3.3 million. The General Investigating Committee retained highly qualified attorneys and investigators to learn what happened. Following months of work, including interviews with every whistleblower and numerous fact witnesses, the committee's attorneys presented detailed, fact-specific information and evidence to the committee in a public hearing. That presentation is publicly available in both video and transcript form. Most of you have taken the time and focus to carefully review that information, and for that I thank you. The evidence is substantial. It is alarming and unnerving. When we ask our attorneys and our investigators who have expert-level experience in white-collar crime and public integrity offenses, but approach this with no mind game other than to gather evidence. We ask him if the evidence showed that laws have been broken and the public trust violated, and they said unequivocally yes. The General Investigating Committee also independently reached the same conclusion and unanimously adopted the articles of impeachment that you have before you today. We take this role solemnly, seriously, and with great humility. We will not tolerate corruption, bribery, abuse of office, retaliation, and all the related charges that have been presented to you. I am confident that you cannot tolerate, let alone defend, these most serious and grave official wrongs. Now, we provided you with a detailed memo regarding the process of impeachment. So I will highlight some of those points. Impeachment is not a criminal process. The primary purpose of impeachment is to protect the state, not to punish the individual. Impeachment in the House is analogous or similar to a criminal indictment and must be followed by a trial in the Senate. A trial that every person interviewed has agreed to attend and testify under oath. The House acts similar to a grand jury. You are not being asked to decide facts or law. That is the role of the Senate. You are only deciding whether there is sufficient evidence to justify further legal proceedings. Now, a few members have voiced their concerns about process, and we've answered a lot of questions about that. References have been made regarding how impeachments unfolded in 1917 and 1975. Those matters were worked out under different rules of the House than we have today. Those matters then are different precedent than we have today. Today we have more detailed rules that makes the committee structure the workhorse and the fact-gathering guidepost for getting this done. The General Investigating Committee has followed the committee rules, the House rules, and the Constitution. All evidence was gathered in accordance with these rules and is consistent with investigations of this kind. These same members that raise concerns about process, though, have not raised concerns about the evidence, the facts. And while Mr. Paxton and his friends have spent time attacking the process, engaging in name-calling, and making political and personal threats to members of this body, he has yet to raise concerns about the evidence against him. Even at his press conference yesterday, neither Mr. Paxton nor any person with personal knowledge has denied any allegation in any article before you. Of course, they get to do that at trial in the Senate. Members, as an attorney, I have always told jurors that we judge people by what they do, not by their name or their title. I have always been a law and order public servant because I believe that having a government free of corruption in America is the only thing that separates us from a third world country. Terms like integrity, honesty, and doing the right thing matter. They matter to me, and I know that they matter to you. Members, we took an oath to preserve, protect, and defend the Constitution and laws of the United States and of this state. So help us God. That's the same oath that Mr. Paxton took as Attorney General. The evidence presented to you is compelling and is more than sufficient to justify going to trial. Putting politics aside, this decision is clear. If what was expected to impeach was a full trial in the House, the Constitution would provide that. But the trial is in the Senate. You are not deciding facts or law today. You are simply deciding if this matter may proceed to trial. You are simply deciding that there are sufficient facts to go to trial. Members, I respectfully ask that you approve these articles. Send this to trial. Move adoption.
The question occurs on adoption of the resolution. This is a record vote required by the Constitution. The clerk ring the bell. Show the Speaker voting aye. Show Mr. Longoria voting aye. Mr. Murr voting aye. Show Mr. Dutton voting present, not voting. Have all members voted? There have been 121 ayes and 23 nays, 2 present, not voting, 3 absent. The resolution is adopted. The chair directs the chief clerk to notify the governor of the House's action. The chair directs the Committee on General Investigating to prepare any further resolution required by the adoption of HR 2377.